So welcome to the second podcast for week 4. In the previous podcast, we introduced the grounds of judicial review and talked about the threshold requirements for natural justice. In this and the following podcast, we'll look at the content aspects of natural justice. In terms of content, there are two parts of natural justice, namely the hearing rule and the bias rule. The hearing rule of natural justice relates to an individual's right to be afforded a fair hearing if a decision will affect their rights and interests. The hearing rule is definitely the most common, and it talks about the procedure for a hearing or for a decision to be made, and it needs to be flexibly applied. The bias rule relates to the expectation that decision makers will act without actual or ostensible bias. And what natural justice requires in a given case depends on the statute, facts and circumstances of each case. In terms of the hearing rule, a key question is, if procedural fairness applies, then what does it actually require in this instance? How do we know if the decision maker has failed to accord procedural fairness? And you must be able to point to something that the decision maker was legally obligated to do and did not do in order to make out this ground of review. The authority for the proposition that the hearing rule should be flexibly applied depending on the circumstances of the case is Kiowa and West. On this slide, there are some key statements from the judgment in this case which reinforce this point. So Justice Brennan said that what is appropriate depends on the circumstances of the case, and they will include, inter alia, the nature of the inquiry, the subject matter, and the rules under which the decision maker is acting. And if you think about it, this makes sense. For example, if your job was at stake, you might want to have legal representation and a hearing to present your case. But if you want to challenge a more mundane type of matter, such as, I don't know, whether you get a university parking permit, for example, this degree of procedural fairness would not be required. So the executive decision-making process should not be clogged or over-judicialized, and there is no need to allow a person to respond to every trifling piece of information which the decision maker might consider. So this comes back to the ongoing tension between achieving the aims of administrative justice on the one hand, which is really focused on justice for individuals, and efficiency in the delivery of public services, which is obviously more about collective justice and the appropriate use of taxpayer funds, etc. Justice Brennan also said in Kiowa that there is a legal duty to disclose information which is credible, relevant and significant, particularly if it is damaging to the applicant's case. In summary, therefore, the hearing rule is best understood as a bundle of potentially applicable interrelated rights, and which of these rights will apply depends on the circumstances of the case. The hearing rule requires a person affected by a decision to be given an adequate opportunity to prepare and present their case and to have their submissions heard. In other words, natural justice is about involving an affected individual in the process along the way to the extent that is reasonable, and they're not meant to be any nasty surprises. So as we said, the hearing rule is a bundle of potentially applicable interrelated rights. The first of these rights relates to adequate prior notice of the matters to be investigated. In the case of Macquarie Uni, Professor Ong was dismissed as the head of school from Macquarie Law School, and the university committee made a decision in a meeting, and then they made a report summarising the allegations against him, which was given to Professor Ong 2 days before the meeting that was to decide his fate. On the day of the meeting, a letter was given to the Vice-Chancellor which contained further allegations, and Mr. Ong had no prior notice of this. So 2 days before a meeting might be okay if you just need to read through a one-page letter, for example. But if there is a very long, detailed report, 2 days is unlikely to be adequate prior notice. So there is no strict binding rule about what constitutes adequate prior notice, and it is a flexible standard which depends on the facts. There also needs to be adequate disclosure of relevant issues to the applicant. That is, issues that are critical to the decision should be disclosed. Again, this is not an absolute right, but it's best practice for government decision makers in order to make better and more transparent and accountable decisions. The duty of disclosure is similar to, but still distinct from, the requirement to give adequate notice. So notice requires the provision of information about the timing and nature of any hearing or other consideration of a case. And disclosure is a more specific requirement that obliges a decision maker to alert the person entitled to be heard to the questions or critical issues to be addressed. So this rule was considered in the case of Kiowa and West. The facts of this case were that there were some Tongan citizens, Mr. Kiowa and his family, who had become prohibited immigrants that could be deported after Mr. Kiowa overstayed his temporary visa. There were 2 prejudicial statements in an internal departmental paper that was prepared for the minister in this case, and one concerned the fact that Mr. Kiowa had changed his address without notifying the department, and this raised questions about whether he was genuine in his desire to legitimately extend his stay. The second statement concerned Mr. Kiowa's alleged concern for other Tongan illegal immigrants and his active involvement with other persons who were seeking to circumvent Australia's immigration laws. The problem was that neither of these 2 prejudicial allegations had been put before Mr. Kiowa before the decision to deport him was made. And as you can imagine, there may have been explanations or defences that Mr. Kiowa could have raised had he been given the opportunity. However, there is no absolute right to disclosure. For example, investigatory bodies are not required to show their hand at every stage of an investigation, which we know from the case of National Companies and Securities Commission and News Limited. So in this case, the National Companies and Security Commission was investigating News Limited in relation to various allegations. News Limited said they should be able to make submissions and cross-examine every witness at every stage of the investigation. Perhaps in an ideal world, if there was unlimited public funds to pay unlimited public servants to conduct unlimited procedural fairness, that would be a desirable state of affairs. But we also need to think about what is an efficient use of public money. So it was held that requiring the Commission to show their hand at every stage might actually hinder the investigation, as witnesses may not speak as freely, etc. And because this was an investigation, different expectations applied. And the Commission did need to keep some cards close to their chest, otherwise one witness might scare off another witness, etc. So News Corp was allowed to do some cross-examination of key witnesses at a later stage, but not all witnesses at every step along the way. So where does this leave us? There is still a general principle, even if it is not an absolute right, that there should be adequate disclosure of relevant critical issues. So this was reinforced in the 2016 case of the Minister for Immigration and Border Protection and SZSSJ, and the Minister for Immigration and Border Protection and SZTZI. The facts of this case were that there had been an inadvertent disclosure of protection visa applicant details by the Department of Immigration and Border Protection, and the information remained on the department website for 2 weeks. The department commissioned KPMG to investigate the data breach, and KPMG provided an abridged report which was made available to the detained visa applicants. And the abridged report didn't include information about entities who had accessed the data that had been disclosed. The department then commenced a process of international treaty obligations assessments, known as ITOAs. The purpose of these assessments was to assess the effect of the data breach on Australia's international obligations in relation to the individuals whose information was disclosed. SZSSJ and SZTZI are pseudonyms for 2 visa applicants who requested an unabridged copy of the KPMG report, and this unabridged report was not provided to them. When the matter came before the High Court, the court considered whether the 2 visa applicants had been denied procedural fairness because the ITOA process was inadequately explained to them, or because the unabridged KPMG report was not provided to them. The issue explored by the High Court was that the obligation of procedural fairness was what the obligation of procedural fairness required in light of the data breach. The court reaffirmed that judicial review was not available simply because of administrative injustice, and the court held that judicial review does not go beyond the declaration and enforcing of the law which determines the limits and governs the exercise of the repository's power. That is not to say that the court must proceed in a normative vacuum, but it is to say that the court can proceed only for that purpose. If in doing so the court avoids administrative injustice or error, so be it, but the court has no jurisdiction simply to cure administrative injustice or error. And this relates back to the separation of powers discussion that we had in the Week 1 lecture. The court then reaffirmed the basic requirements of natural justice, namely that a person is entitled to know the nature and content of information that the decision maker might take into account in reaching a conclusion adverse to the person. The court said, the circumstances of the data breach do not warrant a departure from those ordinary requirements, and there is no principled foundation for converting the ordinary requirement of procedural fairness, that an affected person be given notice, into a duty that the department has to reveal all that it knows about the data breach. The court thus held that there had been no practical injustice in the circumstances of the case, and therefore no breach of the rules of procedural fairness. So let's look at some more examples that are relevant to the duty to disclose relevant issues. In the case of Mia, the Minister relied on new information that was not put to the applicant, and this was found to be a breach of natural justice. In the case of Muin, the tribunal failed to disclose a departmental submission that was made to it concerning the circumstances facing people such as the applicant in Indonesia, which was the applicant's country of origin. Disclosure is not normally required if the material in question was not credible, relevant, and significant. In the case of applicant Veal of 2002 and Mimia, the Minister for Immigration received information that an applicant had killed someone whilst working for the government in Eritrea. The decision maker said they didn't rely on this information and the statement of reasons said that no weight was given to the letter because there was no evidence to back it up. The court said that if information is credible, relevant and significant, it ought to be disclosed to the applicant. Although in this case the person who wrote the letter wanted to be anonymous, this didn't stop the substance of the letter being disclosed, which would have allowed the applicant then to respond to those adverse allegations. The case of Minister for Immigration and Citizenship and Kumar confirmed the decision in applicant Veal. In this case, Mr. Kumar was a non-citizen who had married an Australian citizen and therefore was requesting a visa. The minister's delegate was not satisfied that the parties to the marriage had a mutual commitment to a shared life, or that the relationship between them was genuine and ongoing. So on this basis, the visa was refused. When the decision was appealed before the Migration Review Tribunal, Mr. Kumar was informed in writing that the tribunal had received confidential information stating that his marriage was a sham and invited Mr. Kumar to comment on this information. The tribunal did not disclose the identity of the informant and the full nature of the information. The High Court upheld that it was appropriate that the substance of the information had been conveyed to Mr. Kumar without also disclosing the informant's identity and basically having to show him the letter received. And if you think about it, this makes sense. Otherwise, there would be very little incentive for people to bring to light these types of information that are relevant to government decision-making processes. Another aspect of the natural justice hearing rule is an adequate opportunity to address issues. And this may be relevant where a right to a hearing is denied. Again, there's no absolute right to an opportunity to address or an absolute right to a hearing, so this is why we go through the cases to work out whether it will apply in a particular circumstance. In the case of Bardwaj from 2002, the applicant wanted an opportunity to address the Immigration Review Tribunal, and he was granted this opportunity. Then the applicant requested an adjournment in order to prepare, and the Immigration Review Tribunal refused his request. The applicant was a student who had his visa cancelled, and he was sick on the day of his hearing. His migration agent sent a fax requesting an adjournment, but it got lost in the registry office somehow. And the minister said the decision was made and it should stand. The High Court disagreed, as they said there was no valid decision made as the requirements of natural justice had not been fulfilled. As a result, the first decision could be ignored and the decision needed to be made again, this time affording natural justice to the applicant. Some other examples of where this may be relevant are listed on the slide. In the case of Ala, the Refugee Review Tribunal failed to read important information in the documents that were in front of it, and that was a breach of natural justice. We've also talked about the case of Nguyen, where the tribunal failed to disclose the departmental submission, which meant that the applicant didn't have an opportunity to address this submission. The right to an oral hearing is part of the suite of the natural justice hearing rule, but whether it is available in a particular case is again very dependent on the statute, facts and circumstances. In the case of Heatley, there was a man who was banned from attending race meetings, and the court said he didn't have a right to enter the races. That is, it's not a strictly legal right that he had. But he had always gone before, and the High Court said he should be granted natural justice if that position was about to change. As to what natural justice required in these circumstances, Heatley was entitled to adequate notice about the proposed decision, but not an oral hearing in this instance. However, if Mr. Heatley had been illiterate, for example, that might be the type of situation where an oral hearing would have been appropriate. In the case of Finch and Goldstein, a public servant was promoted, but Finch wanted the promotion and thought he should have got it. The court said that Finch had a right to an oral hearing, but not a right to cross-examine the witness. Again, whether or not there is a right to an oral hearing depends on all the circumstances of the case. Another aspect of the hearing rule is the right to representation. Because there are so many parts to the hearing rule in practice, there's normally at least one ground or one aspect of the ground that you can find for your client, or if it's an admin law exam situation, at least one aspect of the scenario that you can draw out for analysis in your answer. So let's look at the case of Keynes and Jenkins. Keynes was a union office bearer who lost his office, and he wasn't granted representation when he wished to challenge that decision. The High Court said that there was no absolute right to legal representation, even when one's job is at stake. In this case, they looked at the fact that Keynes had studied law and he understood the process and he could adequately represent himself. So look at the professional background of the applicant as one of the factors to take into account in working out whether they should have a right to legal representation. The Wobbs case outlines a number of relevant factors that should be taken into account in determining whether natural justice requires that an applicant for review should be permitted representation. So we need to take into account, firstly, the applicant's capacity to understand the nature of the proceedings and the issues. Secondly, the applicant's capacity to communicate effectively in the language used. For example, is there a need for interpreters in this instance? Thirdly, the legal and factual complexity of the case. And fourthly, the importance of the decision to the applicant's liberty or welfare. So if you get a problem question in the exam on natural justice, you could refer to these four factors in trying to work out whether a right to representation is appropriate. An opportunity to cross-examine is a less frequent inclusion in the requirements of a fair hearing. The right to cross-examination will generally be a requirement where the credibility of witnesses is critical to the decision. If there are two people and it's your word against theirs, you might be entitled to cross-examination if it's the only way to get to the truth of the matter. Harrison and Patterson was a case involving allegations of misconduct against a TAFE employee. There were lots of witnesses in this case, and the court looked at whether the credibility of witnesses is a key issue. And if so, cross-examination is important. So in this instance, natural justice required a right to cross-examine. Is a long delay in the making of a decision enough to constitute a breach of natural justice? In the case of NAIS, there was a 5-year delay in a decision about a refugee, which was held to constitute a breach of natural justice. Particularly where the credibility of a witness is important, time is a key factor. So if a key part of the evidence being relied upon is that the demeanour of a key witness appears to be untrustworthy, extreme delay is going to be problematic. So it's hard to keep an accurate sense of conversations and a witness's demeanour over a period of a number of years. Does natural justice require observance of the rules of evidence? The rules of evidence are not binding on tribunals and administrative decision makers. And natural justice is related to, but not the same as, the rules of evidence. The whole point of most administrative decision-making arrangements is that they're designed to be more flexible and less complex than judicial proceedings. As it says on the slide here, some statutes expressly specified that the decision-maker is not bound by the rules of evidence. Nonetheless, the rules of evidence may provide good guidance, etc. Still, there is a requirement that tribunals and administrative decision makers must rely on logically probative evidence. This was considered in the case of Re Pochi, and the facts of this case are that Mr. Pochi had been living in Australia for 20 years and was in trouble for growing marijuana and was therefore threatened with deportation. He had been convicted of growing marijuana, but the minister said he thought that there was sufficient evidence of trafficking marijuana as well, even though this charge had not been laid against Mr. Pochi. So the evidence that the minister was referring to included that Mr. Pochi had a 30-acre plantation of marijuana, that he had a significant short-term increase in his wealth and was unable to provide any explanation for that sudden increase, and he associated with other people who were engaged with trafficking marijuana. There was also some hearsay evidence from a police officer. So the court said that relying on this evidence was a breach of natural justice, as Mr. Pochi hadn't been tried under Australian law for the offence of trafficking, and there was no logically probative evidence on this issue. There may have been ample grounds for suspecting that Mr. Pochi was involved in trafficking, but there was insufficient evidence to prove this. Does natural justice require reasons for a decision? The High Court case of Wingfoot, which we discussed in week 3, confirms that there is no general common law right to reasons. Note, however, that many statutes do require a statement of reasons. For example, the JR Act of Queensland requires reasons for decisions to which Part 3 applies, and this is one of the advantages of the statutory avenue of judicial review, which we discussed last week. Section 27B of the Acts Interpretation Act of Queensland specifies what goes into a statement of reasons. It must set out the findings of material questions of fact and refer to evidence or other material on which these findings were based. In sum, it is good practice for the decision maker to give reasons at a preliminary stage and allow an opportunity to respond, but this is not a formal requirement. So this brings us to the end of our discussion of the hearing rule. Let's do a couple of revision questions to test our understanding of some of the issues that we've discussed in this podcast. So the first question is, which of these statements about natural justice is incorrect? A, fairness may require or be satisfied by different procedures, even by the same statutory authority in different circumstances. B, the content of the rules of natural justice are not fixed, but vary in accordance with the circumstances of the case. C, natural justice and procedural fairness have distinct and unique meanings in Australian administrative law. Or D, the hearing rule is about the process taken in making a decision, not about what happens after a decision is made. What do you think? So the answer is C, keeping in mind that the question asked you which of the statements is incorrect. A is correct, and that's actually a quote from the case of Heatley and Tasmanian Racing and Gaming Commission. B is also correct, so fresh consideration must be be given to each factual circumstance when considering natural justice questions. C is incorrect because these are two terms for the same thing and they are used interchangeably in Australian administrative law. And D is correct. So procedural fairness is about the fairness of the decision-making process, not the fairness of the ultimate outcome reached. The next question is, which of the following is not relevant to considering whether the common law hearing rule of natural justice has been satisfied? A. Adequate prior notice. B. Adequate disclosure of adverse material. C. The right to an oral hearing. Or D. Giving a statement of reasons for a decision. What do you think? So the answer here is D. A is not correct because issues that are critical to the decision should be disclosed. B is not correct because information which is credible, relevant and significant ought to be disclosed even if the decision maker stated that no weight was given to it, and we saw that in the case of applicant Veal. C is not right because although there is no absolute right to an oral hearing, in the circumstances it may be appropriate to allow a hearing, and again that has to be determined on a case-by-case basis. The only one that is incorrect is D, and although many statutes do require a statement of reasons, this is not a natural justice requirement. So this brings us to the end of the second podcast on the hearing rule. In the next podcast we will look at the second aspect of natural justice, the bias rule.